Good morning, Your Honor. We had a chance to visit with Mr. Cohen. I wanted to warn the court that Mr. Cohen is complaining of being ill this morning. Just wanted to let the court know. We're going to, of course, proceed, but I just wanted the court to know that he had mentioned of that. All right? Thank you.
And Judge, I'd also like to invoke the rule so if the applicant has any vehicles is going to testify in this hearing, it asks that they step out of the courtroom while other people testify.
So look at on
Thank you.
I'm ready, Jeff. In clause number 1650641, State of Texas versus Hayim Cohen. President is Mr. Cohen and his attorney. President is John Oswald, representing the State of Texas. And I apologize, sir.
Nicholas Toops.
Nicholas
Toops.
Philip.
Toups.
And Mr. Paul Johnson, representing Mr. Cohen. Are both sides ready to proceed?
We are, Your Honor.
We are, Your Honor.
And the state has informed that they want to invoke the rule. Is that correct?
Yes, Judge.
So the rule has been invoked, and obviously both parties know what the rule is. So if y'all have any witnesses that are going to testify in this hearing, they must exit the courtroom. And if you could please admonish them regarding the particulars of the rules for the parties. Okay. And with that said, let's proceed. The State of Texas has filed a motion to revoke the bond and deny bail pursuant to Article 1, Section 11B of the Texas Constitution, based on a new law violation, which the state is alleging committed the offense of injury to a child, filed in cause number 1808490 against a minor child identified by his initials YYC. In addition, the state alleges that the defendant misrepresented his health status to the court on numerous court settings, as well as in a hearing held on 1/27/2023. The state argues that these misrepresentations violated his bond conditions to appear in court, and therefore the court was unable to ensure the public safety and his appearing in court at a future setting. This is signed by the State of Texas, Ms. Oswald. Are both sides ready to proceed?
We are, Your Honor.
The state is ready, Your Honor.
State, please start your proceedings if you have any.
Yes, Judge. Prior to the first witness, Your Honor, I'd like to offer in certified copies, all labeled States Exhibit 1 through States Exhibit 13. They include the indictment. States Exhibit 1 is the indictment of the cause that we're moving forward on, which is 1650641. States Exhibit 2 is the bond conditions that were put in place on October 31st of 2019 by this court on cause number 1650641. And then States Exhibit 3 is the original motion to revoke the defendant's bond, which you granted, Judge, on December, I believe, the 4th of 2020. States Exhibit 4 through States Exhibit 13 are the complaints in the new 10 cases that have been filed.
Your Honor, can you do it just one second? Right, Your Honor, we're going to object to States Exhibits 4 through 6 and 8 through 12 as not relevant to this hearing. These offense dates are before the bond conditions were finalized and filed in this case. Object to States Exhibit 2 because that bond was revoked and therefore that's not relevant to this hearing. And
you need 3?
Yes, that's correct, Your Honor. Those bond conditions are not relevant to this hearing because they were revoked. The bond conditions that were filed on 5/4/2022 would be the ones that are relevant to this hearing.
Judge, the bond conditions in States Exhibit 2 were the ones that were also put back in place after he was released from custody after your bond revocation, which is shown in States Exhibit 3. And then all of the other clause numbers are just for the court's reference with regards to the cases being filed. All of the case in which we're proceeding on today was indicted when all of those offenses were charged in complaints. So that's why I'm offering all of these documents for the court's reference.
Defense, your objection is overruled. The exhibits 1 through 13 will be admitted over objection.
Judge, would you like me to present them to you this
Yes,
time?
please. You may proceed.
The state calls Detective Miguel Guerra to the stand at this time.
Also, before we proceed, I'll get you, can you grab a copy of the email? Copy for the state of defense. I received, or this court rather, received an email from the email handle lines@gmail.com, and I think that's the podcaster.
I believe so, Judge.
And she wrote a lengthy email, which I skimmed, basically stating that she had interest in adopting or hosting one of the complaining witnesses in this case, and I just wanted to give a copy to both sides for their review, as I don't keep it myself. I don't read this type of mail in case.
Judge, this witness has not been sworn in.
Can you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Sir, if you could do me a favor, allow. Okay. You may proceed.
Thank you, Judge. Detective Guerra, can you please state your first as well as your last name and spell them for the record?
First name is Miguel. That's Miguel. Last name is Guerra. Guerra.
And how are you currently employed?
With the city of Houston Police Department.
And how long have you been with the Houston Police Department?
Approximately 9 years.
And are you a certified police officer?
Yes, ma'am.
And what division do you currently work for?
Special Victims Division.
And what is that division, kind of cases that does that division typically handle?
Sexual and physical assault of children.
And how long have you been in that division?
5 years now.
And briefly, can you tell me about the type of specific training you've received for that division?
Sexual assaults of children, so we take in-service classes. Sometimes they'll be offered through our own departments or outside classes as well.
And while you're in that division, do you have periods of time where you're on call?
Yes, ma'am.
Are you currently on one of those times?
I've just finished.
How are cases assigned to you in that division?
Through our sergeant, my supervisor.
And at some point, did you receive an investigation involving a defendant by the name of?
Yes, ma'am.
And throughout that investigation, have you been, up until recently, the only investigator on that case?
Yes, ma'am.
At some point in the past, throughout the time that you've been assigned that investigation, have you become aware of social media posts in which the defendant and his family have been featured?
Yes, ma'am.
And what formats are those social media posts being on? And I mean that like TikTok or Instagram or whatnot.
YouTube originally, and then TikTok.
Throughout the more recent months, like the past 6 months, have you been familiar with some of the more recent uploads with regards to TikTok and YouTube?
Yes, ma'am.
And in those, how does the family convey or portray the defendant's health?
healthy back then, but they would say that he's sick, unable to walk.
And did you learn throughout your investigation that he was actually reportedly on hospice?
Yes, ma'am.
Have you reviewed any of those hospice records?
No, ma'am.
Are you aware if he has conveyed to this court that he is on hospice?
Yes, ma'am.
And because of that, he did not come to court?
Yes, ma'am.
At some point in February, did more information with regards to the investigation come forward?
Yes, ma'am.
And can you tell the court what that was?
Yes, ma'am. I received notification through CPS that there was a podcast of one of the children that had made an outcry of sexual abuse.
And when did you learn about that podcast?
On February of this year, just to remember the date.
Okay. Did you make my office specifically made aware of this podcast?
Yes, ma'am.
And did you review the podcast?
Yes, ma'am.
And did you determine who the caller was that called into the podcast?
Yes, ma'am.
And who was that? And is he one of the adoptive children of the defendant, Hayim Cohen?
Yes, ma'am.
Before we move forward, can you identify the person that I'm referring to as Hayim Cohen in the courtroom today, identifying an article of clothing in which he is wearing and the position in the courtroom in which he sits?
To my left, wearing a orange swimsuit.
May the record reflect that the witnesses identified the defendant.
The record reflects that the witness has identified the defendant in this case. You may proceed.
When you learned of the podcast and the subsequent CPS investigation, what were your next courses of action?
To reopen the case, notify you and inform my supervisors that this case has been reopened again without new information.
And then what was your next step after reopening the investigation?
Following up with the complainants, following up with CPS as well, to make sure that we can obtain that video of the podcast and make sure that everything that was being said was true.
And at some point, did we determine to suppress charges and execute a search warrant on the defendant's home?
Yes, ma'am.
And do you remember what day that arrest and the search warrant were executed?
On February 10th.
And is that of 2023?
Yes, ma'am.
Can you tell the court what address that search warrant was executed on?
I believe it's 7907 Duffield Lane.
And is that in Harris County?
Yes, ma'am.
And as far as you know, is that the home of the defendant as well as his biological children, or at least most of the adopted children?
Yes, ma'am.
Were you present when that search warrant was executed?
Yes, ma'am.
In addition to you, who else was present during the execution of that search warrant?
I had CPS there with me, two of them. I also have a crime suppression team who executed the search warrant. I had members of my division as well there with me. We also had Metro Lift on standby. We also had the Houston Fire Department on standby as well.
Okay. Why was CPS present during that search warrant?
Because the children were going to be taken away.
And why was Metro Lift there?
Because of the information that we've heard about the defendant Hayim Cohen and his medical problems, we just want to make sure he had safe transportation for the execution of the arrest warrant.
Was that the same reason why the Houston Fire Department was there?
Yes, ma'am.
When the search warrant was executed, were all of the minor children taken into CPS custody?
Yes, ma'am.
At some point, did you communicate with the child that called into the podcast?
Yes, ma'am.
And you identified him before. What is his name again? What does he go by now, or his preferred moniker? Okay, I'm going to continue by calling him. Did he show you a video while on scene on February the 10th during that search warrant?
Yes, ma'am.
And how did he show that video?
Through his phone?
And did he have access to his own phone, the code to that phone?
Yes, ma'am.
And did you observe the full entirety of that video?
Yes, ma'am.
We'll talk about that video in just a bit. But before we talk about that, I want to talk about what you observed in that home on Duffield Lane.
Yes,
In
ma'am.
addition to the children and the defendant being present, who else was there?
I'm sorry, can you repeat that question?
No problem. In addition to the children, as well as the defendant in the home, who else was there when you went into the home with the search warrant?
My team, the Special Victims Division, and the crime suppression team as well.
Was there anybody there from hospice with the defendant?
Yes, ma'am.
And who was that?
I don't remember her name now, but I know she identified herself as being hospice and care for the defendant.
And did she tell you that he was on hospice while you were there?
Yes, ma'am. She first told me that that man inside is he's bedridden and has a terminally ill illness.
And when you entered, how did you observe the defendant to appear to you?
I did not enter inside the home at the time. I only witnessed him whenever he came out of the house
And how did he exit the home? In what manner?
in a wheelchair man.
And how did he present himself to you as well as HFD?
He appeared that he couldn't breathe.
Was he on oxygen?
Yes, ma'am.
Did he say anything with regards to his health?
No, ma'am.
Did he act like he could not talk or communicate with you because of health issues?
Not with me, but I noticed him trying to obtain the attention of one of the HFD members, tapping her on her arm, saying that he couldn't breathe.
And did HFD end up taking custody with him with a police officer's presence?
Yes, ma'am.
Okay. And where did they end up transporting him?
To Southwest Memorial Hospital.
Did you go with them at that time?
No, ma'am.
But at some point, did you go to Southwest Memorial Hospital to check on the status of the defendant?
Yes, ma'am.
And who else came with you during that visit to the hospital?
My partner, Brian King.
And when you were there, did you speak with anybody from the hospital staff with regards to the status of the defendant?
Yes, ma'am.
Who was that?
That was an attendee.
And what did you end up learning after the defendant was admitted to the hospital that day?
So originally we went there because I heard that the doctor wanted to talk to us. Once we got there, I spoke with the doctor and asked him if he had any questions. He told me no.
Yeah, I'm here to say, Your Honor.
What ended up happening? Did the defendant get admitted into the hospital?
Yes, ma'am.
And how long was he admitted into the hospital that day?
Less than a day for sure. Maybe an hour or two.
Did the defendant then gets transported from Southwest Memorial after he was admitted and then discharged to go to Harris County Jail?
Yes.
Did you help transport him and were you present during the processing into Harris County Jail?
No, ma'am.
At some point, did the Harris County Jail reject his processing?
Yes, ma'am.
And where did he go after that?
To LBJ Hospital.
And before we talk about his visit to LBJ, do you know why he was not admitted into Harris County Jail?
Yes, because the personnel at the jail said that he was in hospice and they couldn't accept him.
And was that information conveyed to them by the defendant?
Yes, ma'am.
So then the defendant got transported to LBJ Hospital.
Yes, ma'am.
And do you know if that was on June 10th or June the 11th?
I don't remember.
Sometime throughout that time frame though?
Yes, ma'am.
Was the defendant admitted into LBJ Hospital?
Yes, ma'am.
If you are aware, how long was his stay at LBJ before he was discharged and brought back to Harris County Jail?
Less than a day.
At some point on June 11th, did the defendant actually get admitted? On February the 11th, did he actually get admitted to Harris County Jail?
Yes, ma'am.
Okay. Did you observe the defendant throughout that process at different various stages?
No, ma'am.
You only observed him at Southwest Hospital, is that right?
Yes, ma'am.
And what did he convey himself to be at Southwest Hospital? Like, what was the aspect that the defendant conveyed to nurses and surrounding people, including yourself, as to his medical status?
Hearsay, Your Honor, medical conclusion and speculation.
I'm asking for an observation.
Under the rule,
So what did you observe him to be acting like while he was at Southwest Hospital after he was arrested at his home?
To me, he looked sick, like he couldn't move.
But yet he was discharged from 2 separate hospitals and admitted to Harris County Jail.
Objection, Your Honor.
Yes.
Was he discharged from 2 separate hospitals?
Yes, ma'am.
Was he admitted to Harris County Jail by February the 11th of 2023?
Yes, ma'am.
Now I want to redirect your attention to the video that Yuki showed you on scene. Did you observe the entirety of that video?
Yes, ma'am.
And did you learn throughout your conversation who took that video?
Yes, ma'am.
And who was that?
Sorry.
Okay. Now, remain approach.
okay,
I'm handing you what's been marked as States Exhibit 14, 15, 16, and 17. You look at those photos and tell me if you recognize each of those photos.
Yes, ma'am.
And do you recognize the individuals in these photos?
Yes, ma'am.
And are these screenshots of the video that you were shown on June 10th, February the 10th of 2023?
Yes, ma'am.
And they are a fair and accurate copy of what you observed in that video?
Yes, ma'am.
Tendering States Exhibit 14 through States Exhibit 17 defense counsel this time and offering in that.
We have a moment, Your Honor. Your Honor, we're going to object to 14 through 17. There's no way to know if this is a true and accurate depiction of what was in the actual video, and he has no personal knowledge of who shot the video, where it was shot.
He has personal knowledge. He said it was that shot the video. He's observed the video. I can ask a few more questions about identifying. I just didn't want to identify the individuals prior to them being admitted.
14 through 17, there is no objection.
Your Honor, I would ask if I publish on that hollow that none of the images be presented to the media because there are still these images in the video and these shots.
So, I mean, the easiest way to do it is, since I'm the person that's going to hear the evidence, is just take it to me.
That's fine. But I'm going to have them talk about these and then hand them to you, Judge, if that's all right. I'm going to hand you States Exhibit 14. Ask the judge, who is the person that we see in States Exhibit 14? And how do you know this?
I have to review the forensic and working on this case.
Okay. And I'm showing you what's been marked as an entered States Exhibit 15. Who do you see in these images? And then who else is in that image? Okay, is the child.
Yes, ma'am.
I'm showing you States Exhibit.
Yes, ma'am.
And the same as States Exhibit 7. Tendering these to the court at this time. At some point after February the 10th, on February the 10th, did you end up taking the phone, showed you those images into your custody for evidentiary purposes?
Yes, ma'am.
At some point later in time, did you, as well as take that phone to the high-tech crimes lab at the district attorney's office?
Yes, ma'am.
Did he consent to the download of his phone?
Yes, ma'am.
Did he provide the passcode for that phone?
Yes, ma'am.
And did you provide that phone to our high-tech crime lab to be able to digitally examine the phone?
Yes, ma'am.
When you observed that video, was there sound that accompanied the video?
Yes, ma'am.
And in that video, what was the defendant Hayim Cohen's actions towards the child?
Hitting the child.
And do you know what he was hitting the child with?
The belt.
And when the child was being hit by the belt, did the child make any sort of sound or action?
Yes, ma'am.
What were those?
He looked scared. You can hear the sound of the belt hitting him, and he was screaming.
In your training and experience, was that reaction one of pain?
Yes, ma'am.
Do you review the forensic interview of that child as well as the child that we saw in State's Exhibit 16?
Yes, ma'am.
As well as the forensic interview of are those consistent with what you saw in the video?
Yes, ma'am.
Pass the witness.
Officer, on this video, you said that you saw a belt
Yes, sir.
being used
Yes, sir.
and some sound, correct?
Yes, sir.
And the action was of Mr. Cohen swinging the belt.
Yes, sir.
How long have you been an officer?
Approximately 9 years.
Have you ever investigated a injury to a child case?
Yes, sir.
And that injury to a child case that you investigated, did it involve parental discipline, spanking?
Yes, sir.
Okay. Are you aware of the Texas Penal Code as it refers to parental discipline and what's allowable and what's not?
Yes, sir.
Okay. Can you quote for us what's allowable and what's not as far as the amount of force that's reasonable?
I believe it's the 9.61.
That's correct.
So a parent is allowed to discipline their child to an extent where you can't physically see no bleeding or marks on their body.
Okay. Was there any bleeding or marks on the body of the child you saw in the video?
Not in the video.
In observing the video, did you see spanking this child on the buttocks?
No, sir.
You did?
On the buttocks, it looked like he was covering himself, so mostly on his arms.
On his arms?
Yes, sir.
Not his upper legs or his buttocks? Just his arms?
I believe his legs too, sir.
Okay. But not his buttocks, you're sure?
Not positively sure. I do remember him trying to cover himself.
Okay. Did you observe this spanking to be particularly forceful?
Yes, sir.
So in your opinion, it was very forceful?
Yes, sir.
Okay. And you consider this to be abnormal parental discipline, is that right?
Based on the overall of the case, yes, sir.
Well, no. Let me ask you this. I didn't ask you about the case. I asked you, was this spanking abnormal parental discipline?
No.
Okay. You said that you heard the child crying out.
Yes, sir.
How old are you?
35.
Right. Well, I'm a lot older than you, but I remember being spanked. Were you spanked as a child?
Yes, sir.
And when you were, was it a scary or exciting event such that you might yell out or say, I'm sorry, don't spank me, that sort of thing?
Yes, sir.
Okay. Was the sound that this child made while being spanked abnormal for a child being spanked?
No.
Okay. So you don't think it's abnormal parental discipline. You don't think that the sound that the child made while being spanked was abnormal either. So do you think that this spanking arises to the level of injury to a child?
Based on the overall of the case, I believe so, sir. But
Okay, hang on. I'm not asking you about the overall case. I'm not asking you about all the different things that you may or may not know in reference to this case. I'm asking you, was this spanking abnormal parental discipline? Was this spanking over the top? Did the sound the child made leads you to believe that this was abnormal parental discipline?
No.
That's what you're
State.
Where was he striking the complainant with the belt?
That's an answer, Your Honor.
No, it was not.
It's overruled. It was not.
Where was he struck with the belt?
It looked like on his arms and on his legs.
And why was he being struck by the belt on his arms and his legs? What action, if you can actually show the court, was the complainant making with his body?
Just had his hands up, was covering himself like this.
So was he doing a defensive fetal position like this?
Yes, ma'am.
Or did he have his legs up to protect his middle part of his body?
Yes, ma'am.
Is that normal discipline in your mind? When a child has to take a protective fetal position while being struck by a belt?
No, ma'am.
And did he scream out in pain?
Yes, ma'am.
Was he ever struck on his buttocks, which would be normal discipline?
Yes, ma'am. Oh, well, I don't remember the video he was struck on his buttocks. But I mean, normal discipline to be struck on the buttocks.
Yeah, but was he? If he's being struck on his hands and his legs in that fetal position, is that normal spanking?
No, ma'am.
And when you have pain outside of normal spanking, is that abnormal discipline?
Correct.
Okay. And with the pain that would have been caused by that, would that be injury to a child?
Yes, ma'am.
And if you need to see the photos again, was he on a couch?
Yes, ma'am.
Was there ever a point in this video where he was asked to bend over and get spanked?
No, ma'am.
In fact, what was his body language like?
The child,
Yes.
like he was trying to crouch down, but in a sitting manner.
Okay. And where was the defendant?
Standing over the child.
Okay. And striking him with the belt.
Yes, ma'am.
Did the defendant that you see here today, was that a person that seemed to require a wheelchair in that video?
No, ma'am.
Was he standing independently on his own?
Yes, ma'am.
Was he requiring a oxygen mask?
No, ma'am.
Was he able to utilize his full access his lungs while he yelled at this child?
Yes, ma'am.
Was it what you have seen when you arrested him that day and the way he displayed himself up until the point where he was admitted to the Harris County Jail?
Yes.
Did what you saw in the video match the defendant and the way he conveyed himself and his health later on?
No.
Pass the witness.
Thank you, Your Honor. In your observation of this video, did you see the beginning of this spanking?
No.
In fact, when the video becomes visible to the viewer, doesn't it appear that this child has backed away from Mr. Cohen and put himself on that couch?
I don't understand.
Well, you just testified that the child was backed away from Mr. Cohen and had pulled his legs up, correct?
Yes, sir.
Okay. So, and you can't see where the beginning of the spanking occurred, can you?
Correct.
All right. I'm going to ask you for sort of your experience we talked about as a child. If you were getting spanked, when you got spanked, when I got spanked, I mean, did you just stand there still or did you back away from it? Did you jump around like most children would?
My parents were a lot more different.
Okay. Tell me about that.
I wouldn't run away. I knew better.
Okay.
Can I object to relevance?
So, I understand, officer. I wouldn't run away either. Just make it worse, right? Right. But you can see how there are some children, some folks that, when they're getting spanked, would be scared, would be afraid, because that's the nature of getting a spanking for being disciplined, but from a parent, correct?
Correct.
Right. I'm going to ask you again. From what you were able to observe of this spanking happening, Was it particularly forceful?
No. I mean, it was forceful, but
Okay.
Let me
Let me ask you something else. So, was it particularly forceful? In watching this child get spanked, was it abnormal for, let me ask this. Was it more forceful or less forceful than the way you got spanked as a child?
I object to relevance.
be worse.
Say again?
So it could be worse.
Okay. Well, it could be worse. It could be less, correct?
Correct.
Okay. So, I'm going to ask my last question. Was this particular spanking, with the small part of it that you saw coming in approximately in the middle, right? Was that abnormal parental discipline?
No.
That's what it's got.
No further questions. Yes.
Your excuse or father.
State calls Steve Clapper to the stand. Steve Clapper, he's in the same room.
Judge, this witness has not been sworn in.
Can you raise your right hand? Do you swear to tell the truth and the whole truth and nothing but the truth, so help you God?
Yes, sir. Yes, ma'am.
That's good. Thank you.
Good morning, Mr. Clapper.
Morning, Judge.
Loud and slow. You may proceed.
Thanks, Judge. Mr. Clapper, will you please introduce yourself for the record, stating your first and last name and spelling it?
My name is Stephen, S-T-E-P-H-I-N, Clapper, C-L-I-P-P-A-R-T.
And how are you currently employed?
I am employed as a digital forensics examiner with the Harris County District Attorney's Office.
And what kind of training, how long have you been doing that?
Approximately 6 years now.
What did you do prior to that?
I was an IT technician, systems administrator.
And what kind of training and experience have you gone through to be able to do your job?
Primarily for this case, I'm vendor certified with Cellbrite, UFED PC, and Cellbrite Physical Analyzer. Those are the main tools I used in doing this examination. I've had about 400 hours of training with the United States Secret Service on computer forensics and additional training, about 100 hours with the National Law&Crime Center, and also trained in time of motion analysis, cell phone tracking via cell phone towers.
And sometime in February, where you brought a cell phone by HPD, specifically Detective Guerra.
Yes, ma'am.
And in addition to Detective Guerra, who else was present when they brought that cell phone?
His partner, whose name I don't recall, and there was a young man that had just turned 18. I could describe him, I don't recall his name.
That's fine. And was this cell phone that young man's phone?
Yes, ma'am.
And did he provide consent for the download of his phone?
He provided consent and the passcode for the phone.
And did you perform the extraction on that device?
Yes, ma'am, I did.
And if you can briefly explain to the court what that involves.
Okay, it's the simplest thing ever when you have consent and passcode. It's a matter of unlocking the phone. There's a device that connects to your computer called the puck, and it's part of the Cellbrite package that provides all drivers a way for the computer to communicate with the phone. And you give the extraction location on the computer at the beginning.
And did you perform a successful extraction of that phone?
Yes, ma'am.
And did you create a report, an extraction report, specifically for a video on that phone?
Yes, I did.
Your Honor, may I approach? Handing you what's been marked as State's Exhibit 19 through State's Exhibit 22. You can review those exhibits.
Yes, ma'am.
Did you create all of those exhibits?
Yes, I did.
And is State's Exhibit 19 the preliminary report of that phone?
Yes, ma'am.
And is 20 and 21 two separate extraction reports from that phone?
Yes, ma'am.
And then 22, is that a Google Map search from information that you retrieved from your extraction?
Yes, ma'am.
And will this help aid in the information that you found with regards to that video?
It's all related to the video.
Tendering State's Exhibit 19 through State's Exhibit 22 to defense counsel at this time.
You said 19 through 22?
Yes, Judge.
Without objection, Your Honor.
With no objection, made 19 through 22 will be admitted as evidence of exhibits 19 through 22.
And Judge, if you don't mind, for me standing up with him while we talk about these, and then I'll present them to you. So, State's Exhibit 19, if you can explain to the court what State's Exhibit 19 is.
This is it's a preliminary extraction report from Saltbright, and this is basically an overview of the information on the phone and identifiers, things that might specifically identify that phone.
Okay, and I'm actually hand all of them to the court right now since we do have copies of them, except for State's Exhibit 22.
Yes.
Okay. So tendering State's Exhibit 19 through 21 to the court at this time. Now I'm going to turn your attention to State's Exhibit 20. Can you tell me what that extraction report is? Okay, Ms. Bailey.
I'm familiar with Saltbright.
Yes, I'm aware. All right, State's Exhibit 20. What are we seeing here in State's Exhibit 20?
Okay, State's Exhibit 20 is an excerpt from the extraction that I did. It's part of what's called the Knowledge C database, which is basically a system log of everything that happens on the phone.
Okay.
Ms. Sullivan, why don't you get to a place where you can stop so I can say something? Please go for it.
Okay. Actually, I think it's a fine place to
Let's
stop
take
right
a
now.
5-minute break.
Yes, Judge.
Let's take those please out, please.
Regards to Knowledge C, the database in which you located the video at, what does that tell you with regards to the ability or the possibility that anything was edited or altered on this video?
I need to make a correction. The location of the video and the presence of the information in the Knowledge C database are completely separate from each other. The Knowledge C database is just a record that the phone did something. The video is where I would customarily find a video that was taken on a particular cell phone.
Okay. So with regards to what you were able to determine from this video taken during that time, it adds up to what you were able to find in the Knowledge C database?
Yes, ma'am.
Okay. And what does that indicate to you?
It indicates to me that the video was taken on that phone. The location of the video was consistent with where I would expect to find it. The information, the metadata information was correct. The video was shot by that model iPhone running that software version. And I have the date and time, the GPS location.
Okay. And in that video, were you able to convert it to an application that would be easier to run on our computer?
Yes, ma'am, I did.
And is that what we have here in State's Exhibit 18?
Yes, ma'am.
Tendering State's Exhibit 18 to Defense Counsel, this video, the converted version, was provided to Defense Counsel prior to this hearing today.
Your Honor, why not take this witness over there for a couple questions before I leave?
Yes, sir.
The knowledge seed database and the other, could you name it for me again?
It's, are you referring to where I found the video?
No, you said that you worked with the knowledge seed database and which other component?
I'm sorry, I'm not.
Okay, so let me ask you a different way. The knowledge seed database lets us know location or phone function.
The knowledge C database lets us know a phone function.
Okay. So is the knowledge seed database only as reliable as what the date and time settings are on the phone?
Yes, sir.
Okay. So if the date and time settings on the phone are altered or are in some way not functioning properly, then your knowledge seed database will be corrupt. Is that right?
It wouldn't be corrupt. It might contain inaccurate. Corruption is a specific term.
My apologies.
The information might be inaccurate.
Okay. So, all right. And then the location and GPS coordinates work off of what system?
GPS.
Okay. And you said that you used Google Maps, is that correct?
Yes, sir.
Okay. And you're sure that it was on Duffield and not on, say, Auburn Lane or Denbridge Street?
That I did it completely blind. I didn't know what address I was looking for. I plugged the coordinates in, and it took me straight to the address that we talked about.
Okay. And how accurate is it? I mean, is one accurate? Possible, let's say the next street over, which is Auburn Lane, or the street right at the corner, which is a few hundred feet away, which is Denbridge. Would that, I mean, is it possible that would be off that way?
I don't believe it would be possible to be off by that far.
Okay. That's pretty right.
Do you want to, so you have no objection to the?
I have no objection.
With no objection made, state exhibit number 18 will be admitted into evidence.
And then I have nothing further for this witness judge, just to publish this video to you.
Make a motion to it.
You want to view it here or? With the sound button?
Your Honor, for the record, I verified that this is the same video that was provided to defense when we first came on the case, and it's been provided in a couple different forms, but it's the same video. Thank you. It's all the same video.
Pass this witness, Your Honor.
No questions.
May this witness be excused?
Yes, Your Honor.
May it be excused, sir? Are you
Yes.
witness state?
This time state rep.
Oh. What is with you and that stuff?
It's only your courtroom, Judge.
Feel bad.
Yeah, I'll fine.
State having arrest defense.
Judge, the defense would just tender an order offer defendant's exhibit 1, which is a certified court copy of pretrial supervision and bond conditions that were filed with the court and signed by the judge on August 2021 and signed by the defendant on May 4th of 2022.
She has no questions.
What number, say it was?
Defense exhibit 1.
With no objection made, defense exhibit number one will be admitted into evidence. What date was that video purported to be taken?
February the 8th of 2023.
And defense reps do not want this.
Both sides resting
specifically says violated a condition of release related to the safety of a victim of the alleged offense or generally the safety of the community. What you have before you today is the allegation that the defendant violated his conditions of bond by committing a new crime of injury to a child. We would argue to you that the officer himself said that this was not beyond the scope of parental discipline, and therefore he did not commit a new offense. The additional offenses that you have in front of you by way of State's Exhibits 4 through, I think it's 12, all of those offense dates predate those bond conditions that were contained in Defense Exhibit 1. We would argue, Judge, that first we need to discuss what bond conditions we're talking about. The state contends that it's what's contained in State's Exhibits 2. We contend, Judge, that in State's Exhibit 2, those bond conditions were revoked with his bond on December 10th of 2020. And then in State's Exhibit 3, the court reinstated his bond at $75,000, but State's Exhibit 3 says nothing about bond conditions. And there are no additional bond conditions in the court's file until those conditions that are before you in Defense Exhibit 3, which were filed with the court in November of 2019, I believe, but were not signed by the judge yourself until August of 2021, and were not signed by the defendant until May of 2022. I don't know what the oversight was or why they were not, but I don't know why we would have filed new bond conditions if they were already in place in State's Exhibit 2 as the state is alleging. So our argument is that the bond conditions contained in Defense Exhibit 1 are what we're talking about here, and all of State's Exhibits 4 through 12 offense dates occurred before those conditions were signed for and filed properly with the court. Additionally, and I have a case site, Judge, I didn't print it, I apologize. It's a Court of Appeals case out of San Antonio. The site is 648 Southwest 3rd, 435. And I'm using that San Antonio case because there is a paragraph at Headnote 14 which quotes a lot of 14th District Court's opinions for different things. But the gist is that the trial court must ascertain to some degree what led to an arrest. The answer cannot simply be that the defendant was arrested. The fact of an arrest is different from the truth of the violation. Additionally, using the charged name as a basis to determine whether a violation occurred is tantamount to hearsay, which raises serious questions of reliability that a trial court must avoid when detaining an individual without bond. So the allegations made in State's Exhibits 4 through 12, the additional charges, sound back, but we have heard absolutely no evidence to prove that beyond any burden, much less a preponderance of the evidence. So we would maintain that the defendant has committed no bond violation. Additionally, if we were going to go with the state and the judge or court for some reason decides that a violation was committed, 11B says that the violation of a condition must be related to the safety of a victim of the alleged offense. We would argue that the alleged offense we are here about in this case is the 2019 indecency with a child under the cause number that begins with 165, I believe. The victim in that case is not the same child that was in this. I believe that we would argue that the legislature intended, if you're going to deny a person bond entirely, it is related to the safety of a victim so that a defendant cannot terrorize the same victim over and over and over again and be allowed to let out a bond. That is not what's happening in this case. These are two separate children, and the defendant has no access to children in his home anymore whatsoever. So therefore, that does not meet the burden required for Article 1, 11B. Additionally, for the general safety of the community argument, I believe the state is arguing that because apparently the officer believes that he's healthier in that video than he appears to be today or he appears to be at the time, that is tantamount to a bond violation or somehow affects the safety of the community, and we would argue that that's just not true. But the officer doesn't know his health conditions, and we've heard no testimony from medical experts or anyone else to determine what his medical issues actually are or if they exist or not. Additionally, if in fact, again, we take the state's he's not sick, then, but he is so pretending to be or holding himself out to be, if he is saying that he is wheelchair bound and I don't understand how the community would be harmed by that, or how it's a bond violation. So, in conclusion, Judge, as I said to start, the burden is an extraordinary act of preponderance of evidence, but it's incredibly specific, and I don't believe that the evidence that we've heard today and the evidence that is before you meets that burden. So we would ask that you grant that.
State briefly.
Judge, just to address the issue of the one bond conditions to the next, the reason why the one bond conditions that we have in place from October 31st of 2019, you did revoke those in November of 2019. He was then placed into custody for a series of days in December of 2019. The reason why we did not put those conditions in place from November of 2019 until May of 2022 is because he never came to court throughout that time. And you know that because you were here. And his defense counsel approached and he was never present. And the reason why he was never present from about February 1st of 2020 up until February the 11th of this year was because he was reportedly on hospice. We then had a hearing on January 27th of 2023. But prior to that hearing, his defense counsel somehow got him to sign those bond conditions, never him being present. So that's why he was not on bond conditions the entire time, because he was purportedly sick and couldn't be here. And on January 27th of 2023, we had another hearing with regards to the status of his health. Throughout that entire year, we requested through his defense counsel, because he was never present, for him to provide documentation of his diagnostic paperwork and results from a medical professional who stated that he was terminal from 2 diseases. He never provided that. He still has not provided that. And that was January 27th of 2023. When you and I were here in court on that hearing, and he appeared via Zoom, and I would like for the court to remember the fact that he appeared bedridden. He in fact coughed up, had his son sitting next to him, and acted as if he couldn't even sit up in a wheelchair during a court hearing, which was the first time he appeared for more than a year on this case. After that was when we got the information with regards to the podcast. At that point in time, CPS went in and we
I
actually...
would not object to the state testifying about what happened. None of this is in evidence we have heard, none of this from a witness, and it's not in the court record that I've been able to see.
Well, I've been present all of the years, so I know the history of the case.
Well,
So
the court will know that, but I would object to her.
I know that, and she's just reminding the court, but I do remember the history of the case, and it's just for argument. Go ahead.
So we are here now on his second violation. Whatever bond conditions were put in place, he's very aware that he's not, and so is pretty much the entire community, they're not supposed to sexually abuse children or physically abuse them. And we have proof that on February the 8th, 2 days before we executed the search warrant, after he appeared in front of this court to not be able to even come to his feet or come to court, that he was up on his feet beating a child with a belt. And no matter what that officer stated, he helped sign those charges into place, and it's not whether his opinion or not, it's the court's opinion, whether or not we've reached the preponderance of the evidence in that case for injury to a child. And I would argue to you after you watch that video that that is not normal discipline of a child. It's not. Hitting a child about the chest, hands, and feet area as they cower on a couch and scream because they didn't perform on a cell phone or a TikTok video or whatever he was trying to have that child do is not typical discipline. The child screaming indicates pain. The child subsequently verified that pain in his own forensic interview. That is an injury to a child. That in and of itself revokes the bond, and it should then be denied bond on the case in which we are here. But I then would argue to you that that video shows so much more to this court about the safety of the community. While I agree that that child is not the child in cause number 1650641, that child is a child of our community, and the safety of the community, including that child, should be considered by this court. I would then argue the fact that he has misrepresented his health and his ability to stand on his feet and get to certain places and be here in court, and he's done that for more than a year, is shown very directly in that video. He has misrepresented to this court his ability to function, to stand, to be present, and that misrepresentation has kept him from being in court on this case and the ability to move forward on it for more than a year. That in and of itself is an issue of the safety of the community. And I would beg the court to see that as his inability to appear in court unless he is actually in custody. So the state would argue that we have met our burden, and we would request that you revoke his bond in cause number 1650641 for the second time and deny him a bond in that case. And then in all other cause numbers, we would either ask for no bond, but if the court's not willing to do that, request very high bonds in all the other cases.
After reviewing the evidence in this case, I know you all are newer to the case, but I do know the full history of the case, and this court has asked repeatedly for records regarding your client's health, and I received records. However, they were not clear, so I asked for testimony, and I have never been provided with a definitive answer whether your client is in hospice care or not. And based on what I received, I don't believe that there's ever been an actual treating physician that diagnosed him as terminally ill. And I had a hearing, and every doctor or every person that testified was basing it on some records that in the end came from the defendant's own history of him having a terminal illness, but yet I have not received any, after asking both sides for the records, which I've reviewed. I've had the state review them, the defense has an opportunity to review them as well. I never received an indication that an actual physician has stated that he has a terminal illness. And I also do remember, and it was great theatrics that day, but yet on this video, he's up and down, able to discipline. I did not play with my bond conditions. And I do believe that the state has proved by a preponderance the allegations in the injury to a child case. And I also believe that you have tried to misguide this court with respect to your illness. You will be held at zero bond. I'm not going to give you another bond until this, we're going to try this case as fast as I can. How long is it going to take?
Judge, we have expedited with going through our crimes database, all of the other evidence. So I'm thinking that's probably going to take a couple of months. I would say the beginning of the next year would be the earliest.
Defense?
Your Honor, as soon as we can get the evidence together, this case is very cooperative. We've been able to work well together to get this as quickly off your docket as possible, as close questions. And as soon as we get it, we'll be ready to go.
And the issue is not about getting it off my docket. The issue is getting it tried as fast as I can get it tried, because sometimes, y'all may be seated, sometimes these cases tend to languish waiting on discovery, and I just want to make sure that both parties knows that I can try cases to get it tried this year if possible.
I will do everything in my power to do that. We were able to dump this one because of the consent and expediting it. I have pulled the strings to get the same tech to be able to review the rest of it, but there's quite a few devices. So I just can't give you an idea yet.
Let's put it on the front burner, and I'd like to try this case as soon as possible. I can try this case in less than a week.
Understood, Your Honor. The state's made me aware of sort of the sheer volume of information, both report and electronic, especially electronic. They've been very cooperative with us. So as soon as it's ready, we'll get it reviewed.
We'll communicate that with the court. As soon as I have everything that I provided in this account, I'll let the court know. But this also was one in which there's still investigative portions of it to be done, because these new charges were brought about pretty quickly when normally the investigation is on the front end.
Okay. So we'll reset this case for a month so I can get brief. The client or the defendant will come to court via the Harris County Jail, and let's continue. And I want status reports every month with respect to where we are on the discovery, so I can try this case as fast as possible. This hearing is concluded. Thank you.